Family's a complicated thing, and whether it's funny, the parallels between divorce law and probate is there are a lot of parallels, and the primary parallels is that families are imperfect, families are inclined, if not nurtured, to deteriorate into relationships that are not good. Phrase toxic relationships, I think, is used far too liberally. But the fact is, you can have family relationships that can be permanently impaired because of disputes over things that may not involve a lot of money.
Life's Third Act is a podcast dedicated to helping you get the most out of your retirement. Sponsored by TuckerAllen, Attorney-CPA Joe Cordell features guests each week to discuss prominent topics for those over 55. Here's Attorney-CPA Joe Cordell.
Welcome. This is another episode of Life's Third Act. This week I want to talk to you about heirlooms. And some of you are saying, what are heirlooms? Heirlooms are those items that you'd consider personal property. They're stuff, they're things, the law calls it personalty, but it's things that are not real estate. They're not a fixture. They're not attached to real estate. They don't have documents of title. Like, for example, a car is typically not an heirloom. I guess it could be, but typically when you're talking about heirlooms, you're talking about things where it's not clear from any filing with any government entity who owns it because it doesn't have documents of title. You know, chairs and couches and all those things, jewelry. They don't have documents of title per se. So generally these things are called heirlooms because they often are passed down for multiple generations. In some cases, it's something, though, that could be very valuable for emotional or personal reasons that is fairly new. Maybe your mother bought it or your grandmother bought it, and it's given directly to you. So the better way to characterize this discussion is to think of it as a discussion about what do you do with the stuff that we might call personal property. And what stimulated this show, in fact, was an article that I thought was really well done, and it was in the Wall Street Journal. Ashley Ebeling wrote this article, and it's called Pass on Your Heirlooms, Not Family Drama. It's a pretty good title, and especially when you know kind of what the article's about. It's about the fact that often personal property can cause a disproportionate amount of conflict given its relative value to other things. So often it's not the money that these things are actually worth. It's about the memories or the emotions or whatnot that attaches to it. Sometimes it's just about some conflict in the family in which maybe it's expressing the conflict through an argument over personal property. It's not really so much about the personal property. It's about maybe this simmering sort of family dynamic that has been there for some time and perhaps may have exploded to the surface, for example, for the first time after when the patriarch or whoever it was, the common ancestor, died.
Strong roots are essential for a healthy tree, especially your family tree. That's why you work hard to take care of your family every day. At TuckerAllen, we know that taking care of your family means planning for the future. Our team provides personalized estate planning to help you protect your family, your legacy, and your future. From wills and trusts to long-term care and estate planning, count on TuckerAllen, personalized estate planning made simple.
So the article, I thought that Ashley raised some good points. If you pronounce it Ashley, maybe it's Ashlea. But I thought she raised some good points. And I wanted to, I'll make reference to a few of her points, but mostly I want to add my own thoughts on this subject because it is true. She's on the right track when she talks about the fact that attorneys often do overlook this. We, attorneys, are guilty of thinking, let's focus on the big ticket items. So we know the things that have great value are important, especially when they're real estate, stocks and bonds, any sort of financial security. immediately our mind, as professionals, go to those things and think about, who's going to get them. Certainly tax-deferred assets, retirement assets. These are always in the forefront of our considerations when we're doing estate planning to be sure that we've covered these things. And a similar thing, when I was practicing as a divorce lawyer, it was a similar approach where often our focus would be on the big ticket items because we're being practical, right? But divorce, kind of like probate, is not always about practical considerations. As a matter of fact, it notoriously is not about practical considerations. It notoriously is fueled with things that have very little monetary value, but drive in a decisive way the process of divorce. And I would even argue, to some extent, probate, and maybe even to a greater extent, depending on the family. And these things are jealousy. In divorce, it's betrayal. It's that dynamic where someone once said you can't hate anybody as much as somebody that you loved at one time. So there's some truth in that. So there's a lot going on in terms of family relationships. And I think that makes its way into both those scenarios. And I'll add this parallel as well. I can tell you the personal property sometimes became a very big deal. There were even occasions when we went to trial over the personal property when everything else was settled. But these are often cases where there's a lot of bitterness between the parties. It's not a business consideration, or even, I should better characterize it, it was not a financial consideration. It was purely about somebody feeling betrayed or somebody feeling vindictive, all that maelstrom or pot of emotions that can make for a lot of expensive litigation, a lot of lawyer fees. I don't care what the issue is, what area of law it is. If families or the parties are driven by things that are much less about practical considerations, or I'll say rational things, then there's no limit to what people can and have spent as a percentage of their estate, whether it's a marital estate or a probate estate. So in the divorce context, I remember one situation where these were both professionals. Wife was a school teacher. Husband was an officer at a financial institution, bank. And they were very bitter. The husband in this case had an affair, and there was a lot of resentment about that. And this marriage had been substantial, like 15 or 20 years. And we resolved everything, including some pretty large assets. Those things we got past, albeit everything was, a little tugging and pulling. But when it came to the personality, the wheels fell off the bus. I'm just telling you, that was the point where the lawyers, in this case, we really did not want to see this case go to trial. Contrary to the stereotype of lawyers, that some people think that lawyers gin up, any sort of conflict they can in order to make additional fees. I'm not saying that there are no such lawyers. Yes, there are lawyers like that. But do I think that that's generally true? Generally, lawyers have work, sadly, if you're a divorce lawyer or even a probate lawyer. And so there's no need for that. And I can just tell you that in our case, on both sides, we were trying to get this settled, so much so, and even the judge was wanting to see it settled. The judge was impatient with it because judges often don't want to go to trial. If you thought otherwise, I could see how you might think that. You think, well, that's a judge. It's what they do, is they're supposed to judge. In order to judge, they need to hear the cases of the respective parties. That's how else can they judge? So they go to work every day assuming that they're going to be judging a dispute. Well, that's really not the way it turns out. Being a judge can often be a very relaxing, a very non-demanding sort of job. It's a job that may be elective. Some cases it's appointed, and depending on the county. In Missouri, you have both. You have some counties where judges are elected for certain positions, and others where the governor or typically the governor would appoint judges in other counties. So judges prefer to have a leisurely day, and it's not leisurely when a judge is having to sit and during a trial and make decisions, split-second decisions. Objections are made. The judge has to either abstain or overrule those objections. If the judge gets it wrong, he or she is going to get reversed on appeal if the case goes on appeal, and that makes the judge look bad. And so judges would prefer to not be in that situation where they have to spend their entire day, in relatively stressful conditions. And not all judges feel this stress, incidentally, but you have to understand that not just the lawyers have to be 100% dialed in and have to be attentive and bring their A game to court, but judges too have to. It's up to them to make a decision on the spot. They don't have to. Sometimes they'll delay it, but mostly it's decisions on the spot. Anyway, so in this case, the judge also wanted to avoid a trial. So the judge actually ruled after we had each had a sort of informal hearing and we put before the court that all other issues had been decided. The judge ruled then that the parties would each take turns selecting items from a list that the attorneys agreed was complete. So we had prepared lists. Each of us had a property list that was attached to the pleadings, and we compared them, and ultimately we reconciled them, so we agreed on one single list. And once that was done, the judge ordered that the parties take turns. So here we have a list of, I don't remember the name, it's at least 100 items, and it could have been 150 or more. It was a long list. But we spent the better part of a day sitting in the conference room of our offices, each taking turns selecting from the list. And these were often not very expensive things. I don't want you to think that what these people owned was valuable collections of items and antiques and valuable jewelry. There were some items that had some value, but that was really not what this was about. And this is an illustration of the sort of conflict that can result regarding heirlooms or personal property. And so I think that attorneys, we are guilty in estate planning of sometimes not encouraging our clients to think deeply enough about this subject. So hence, I want to take a show and talk about some things that you can do to deal with those. And some of these are ideas that were in the article, Pass on Your Heirlooms, Not Family Drama, is Wall Street Journal article. So Ashley, I had some ideas, but I want to add some things to that. But either way, we equip you with the capability of being able to head off what could very well be the deal killer in your being able to transmit, to pass your estate to the people you love in a way that they're harmonious through the process, and more importantly, after the process with one another. So just focusing on the big ticket items are important, obviously, but really there may be more potential trouble that would be brewing in those things that are often called heirlooms. So let me explain to you how these are handled in the probate estate. So in your will, you doubtlessly have what's called a residuary clause. And the residuary clause would have a provision that whatever else rests in my estate, I want to go equally or in shares or whatever it might be to, and then you name who your children or your grandchildren, whoever that might be. Now, you can above that, before you get to what's called the residuary clause, which kind of captures whatever's left, above that you can make specific bequests. So you can choose to list in your specific bequests certain things that go to certain people. That can definitely be done, often is done. But usually it's not a mechanism to deal with the many items that might cause some resentment. Yeah, you can identify the things that you think these have notorious potential. These are likely suspects in terms of causing conflict. So you can often pick out those things, but But you have to remember that there are out of probably 100 plus significant items you own, and I'm not assuming you're rich, but I'm willing to argue that these are significant in some way. They've been in the family a long time. Maybe a child grew up and this was familiar to them. They associate it with you. There could be a lot of other things. It could be from your ancestors, grandparents, et cetera. So there are just a lot of things, more than you normally would list as specific bequests in that paragraph. But just so you know, that would be the sort of law school answer. Where do you provide for specific items? Well, it'd be specific bequests. But realistically, that probably isn't the place for you to fully handle those things. Now, you can handle it by having an attachment in which you have an inventory of items and you list who they go to. That would be a way to make it clear, and you attach it to the will at the time it's made, not later, so you can be sure that it's going to be valid, it's incorporated into the will. But let me hurry to add that many of you I know are not counting on a will to accomplish this. Many of you have in place a living trust, a revocable trust, whatever you want to call it. If you guys watch this show enough, you have that in place, and you know then that you can have a document in which you inventory your personality, and this affidavit of gift is what transfers these items into your trust. So all your personal property is in your trust if you've been a regular listener of this show and have just done the things that we harp about, then you would have done this. It still, though, doesn't answer the point of this show, which is to talk about how are those distributed once they're in the trust. So whether we were talking about something that's an attachment to your will, or whether it's something that you have as an affidavit of gift into your trust, it does mean, though, if it's in your trust, it's not going through probate, thankfully. So that's a marvelous advantage, as you know. Those of you, though, who simply have a will, then yes, the personal property does still go through probate, even though what some families do, if they don't have items that they require a document of title, like real estate or like cars, or financial accounts, a bank account, stock, security. Those are all things that they have a title, a certificate of title, in which you have to get that changed. And the only way to do that, if you've not done it by way of a trust or by way of a transfer on death clause, et cetera, then the only way to accomplish that is you've got to go through probate to get those changed. That's the primary function of probate, is to get documents of title addressed and determine who's to get the assets. But the things we're talking about now, that's not an issue, because these are things that are, chairs and cameras and electronics and all those things, that dishes, all those things where, what you could do if you had a relative, and these are what poor people do, I think, regularly, is that, their grandmother will pass away and they'll all go over to grandma's house and get stuff and hopefully agree, or maybe it's first come, first serve, but they come and get stuff and they walk away and nothing's ever filed with the court. Well, if there's no real estate involved where there needs to be a change of title, which means it requires a probate ruling to get a judge to bring a gavel down saying that the person whose name on that piece of paper has passed away, and the court now says, Joe Smith, her son, now owns it, for example. Without that order from a court, that document can't be, or that real estate can't be transferred. Same thing for cars, same thing for bank accounts. I mean, all those things, you have to have some mechanism by which you change the name. Now, transfer on death, again, payable on death, you can have, even with real estate, you can have, a provision in which you have what's called a beneficiary deed. You can have it transfer also, in which there is no probate court required. But these are alternatives to probate, and the best alternative to probate, of course, is the revocable trust. But I'm going to focus here for the next few minutes, though, on what most people sadly do. They don't have a trust, and they don't have mechanisms to deal with those various things, so they have to go through probate. And that's the thing that is very profitable for lawyers. I'll just tell you, it's by statute that lawyers are paid, and the statute is pretty generous. And also, it means money being paid to courts. It means delay. It means an invitation to creditors out there to come and if they have any claims, assert them. And if there are any valid claims out there, that's going to come off the top before anything's available to be distributed. So there's lots of things about probate that you just don't want to do, and I've talked about that on other shows. But I did want you to understand that even though these items don't have those certificates of title, it still doesn't change the law. The law is that they still were owned by that person who died, and it's now for the probate court to make the decision who owns it now. Even though, as a practical matter, some people never bother doing that if their relative didn't own real estate, didn't own documents of title and of anything such as bank accounts or retirement accounts. It had none of that. I mean, there are people out there, maybe you're one of them, who don't own any of those things. And generally they would be poor. And so in those cases, yeah, it just means family comes over and gets the stuff they want, and hopefully there's not a fight. And if there is, they may settle it there, I assume. But they end up, it gets done in some fashion. Probably not the way that Grandma wanted it done. Grandma may have had specific ideas. So what are some ideas as to ways to head off this conflict, which notoriously can be grossly disproportional to the value of the stuff we're talking about here? So what we're about to talk about here is applicable whether we're dealing with a probate estate, meaning a will, or whether we're dealing with a trust. Either way, these considerations I put before you. One is that you give, whether it's your trustee or your personal representative, you give them authority and a process by which they can do it. If nothing else, you give them the authority. Now, I think just giving them the authority may not be enough. I think that you have to give them more direction. So you might say to your personal representative applies to will, trustee applies to trust. So I'm treating these the same for purposes of solving this problem here. So I'll use trustee. So the trustee, for him to know that he's to distribute those assets as he sees fit, is an invitation for a lot of resentment toward him. And I don't think that it's going to be the ideal solution. I think often you have to give him more direction. You may say that I want these certain things to go to certain people, that you can be very specific about that. You can even prepare a list and date it if you want to make provision for it yourself and not have your trustee be saddled with making those decisions. So some people will prepare an elaborate list in which they go through their house and identify things that they think are going to be of interest to their family, and they specifically state that it's to go to them. In that case, it's not the trustee having discretion. In that case, it's the trustee of simply doing what you said to do. That's one approach. Often, that may still cause some resentment. I think if you use that approach, you should also make a point to talk to your loved ones about the items that are most important maybe to them and explaining who you're giving it to and why. That's something that is often easier to do than it is to talk about financial assets. Notoriously, people don't want to disclose what they're going to do when they die, often with their kids. I've found this to be true, that somehow it's a conversation they kind of want to postpone. But it's a little easier to do it if you're talking about the heirlooms, I think, typically. Either way you do it, whether you give discretion to the trustee or whether you provide a list, you at least have a mechanism for solving it. But it can get more creative than that. I gave you an example of what we did in this divorce where people took turns. You can have them draw straws to select items. You can have appraisals done, incidentally, for things that have significant value and agree that ultimately you want the values to balance. It doesn't solve everything because, as we talked, it's not just about money, but it does at least get rid of that money resentment where somebody may have gotten one item that, say, that was far and away the most valuable thing monetarily. Maybe it was a ring, a piece of jewelry that had been in the family for a long time. And so it's really difficult for the other things to offset that. So if there's no provision to offset it, then you really want to think about having some provision in which you discuss why you chose that route. Better still, though, is to try to find a way to counterbalance it. But it's often better to avoid resentment if your goal is to end up with something resembling a balance in monetary value, if that's your goal. And I do think that generally helps, is to shoot for something that balances financially. It doesn't solve everything, but it's a good starting point. And in order to do that, you have to be prepared to get appraisals of stuff that have a value, say, over $1,000. And I know appraisals are not cheap. I've shopped for people who would do appraisals for estates that were not very large, and I knew that I didn't want to use 10% of the estate in order to get appraisals. So you do want to have somebody come in who can give you an estimate. And often antique dealers, people who deal irregularly in auctions, anybody who may be involved in flea markets, and so they have an eye for a broad variety of things. These people are often very cheap, and not to mention they'll offer to buy things if you decide to do that. But bringing somebody in and telling them on the front end that your intention is not to sell it, so you know you're getting the full estimate of value from them as opposed to the value they'd give you if they thought it'd be what they would be paying if they bought it. So you can get these values inexpensively, and you can get it often from one person for a broad variety of stuff. Now, if it's art, you probably need somebody specifically for that. Jewelry, you need somebody that has a good eye for valuing diamonds and whatnot. So that often is somebody who is pretty authoritative. But I think appraisals are often not done for personal property just because it's inconvenient, and it may delay the distribution a little bit. But I think that often an appraisal, if people know that they ended up with something balanced in the scales, that'll often count. But if it's an heirloom that's not related to money, a shotgun that your grandfather taught you to shoot with and was very important to you, and yet it goes to, your brother who may have had no interest for whatever reason. Maybe it was just something that a trustee or a personal representative just arbitrarily decided. Those are things that produce a lot of resentment, and particularly when the brother doesn't want to make it right, the other brother. So sometimes parties themselves, if they receive something that isn't appropriate to them, that isn't of as much value to them, often they can solve it among themselves, but that's when a family's pretty good in terms of their relationships already. So if the family's solid and they're close, then yeah, they can iron those things out and they can fix it. So that's the beauty of having, if you have children or grandchildren who are tight and they have strong relationships, generally, that sort of bond makes it difficult for items such as these to cause lasting damage. It's those other families which are just as common where the relationships are more fragile, and you throw in spouses, in-laws. These spouses are often the source, quite frankly, of some of this conflict. It's fed by a spouse who has an interpretation on events that the sibling might not otherwise have had. So family's a complicated thing, and whether it's funny, the parallels between divorce law and probate is there are a lot of parallels, and the primary parallels is that families are imperfect. Families are inclined, if not nurtured, to deteriorate into relationships that are not good. Phrase toxic relationships, I think, is used far too liberally. But the fact is, you can have family relationships that can be permanently impaired because of disputes over things that may not involve a lot of money, but involve other stuff. And so that's the point that we talk about here. I would say that a democratic process would, if nothing else happens, one process would be to simply have everything sold and the money divided. But while that's that's a logical process. This couple I was giving you an example of, they didn't want everything sold and the money divided. They wanted the stuff. So that's the reason the judge did what he did. Plus, selling it was going to result in huge reduction in its value. You know, when you sell toasters and things like that, a huge discount in value. So it's something that you don't want to do unless you need to do it. Now, if nobody has an interest, it's the opposite problem. Nobody cares about any of the stuff. And I'm told that more and more Gen Z is really not that interested in stuff. So I'm told. I don't count on a lot of Gen Z people watching this show, but if we do have some people from that generation, I'd be interested to get your thoughts. But what I'm experiencing and seeing in my family, my daughters who we offer stuff from our home and other things, and they don't want any of that stuff. They want to go out and get their own stuff. And things are cheaper now. A chair, a furniture. It's amazing how affordable things have become. And I don't know if that'll continue to be true, but we have seen, because of labor costs in Asia primarily over the last 20 years, we have enjoyed pretty low prices on a lot of things. And I think kids just assume that they can furnish their own house. And I don't know that they attach, and this is the thing that bugs me most. I'm not sure that generation attaches as much emotion or value to heirlooms, to things that were once important to other members of their family or that were historically important in their family. I'm not sure that the Gen Zers appreciate that. And I may sound like an old fogey talking about this, and I hope that I'm wrong. But I mean, if we did see a trend like that, then whether it's good or bad news, and I don't regard it as good news entirely, there won't be much dispute over personal property and heirlooms, what I've dedicated this show to, because these kids are going to say, fine, take it. I'm going to buy a new China set or whatever. And that literally is an example of what we've dealt with in our house. Is we have more than one set of China. And it's come from, when people pass away on either side of the family, you get this sort of thing. So we have more than one set. And our kids, they just don't really have an interest. And I have two daughters in their 20s, upper 20s now, or mid-20s, but they don't really have an appreciation for it. So if this trend continues, Justin, we'll have to get rid of this show because it's not a problem.
It's funny that you mentioned that because my wife's mom got mad at us for not putting China on the registry.
Now, why did you not put... Oh, wait, first of all, how old are you, Justin?
43.
Okay. You look like you're 23, but anyway. So, but how long ago was this?
18 years ago.
Okay, so this is on point. Why is this? Why not?
Partially, we don't entertain that much. And I don't know, it's something that never really entered our minds. We have our regular plates and that's what we use.
So maybe in a way it's fashion, that the idea of China, there's no place for it.
Yeah, that's another situation is we have to store it.
Yeah. And minimalism is a thing now too. So you would be considered, Justin, a millennial?
Technically Gen X, but like the very edge.
Okay.
Kind of like an early millennial or a late Gen X. It's technically a micro generation. It's Zennials is what they call it.
So we need to have somebody opine on what's going on with Gen Z.
Yeah, maybe we can have Marley comment on that.
Yes, yeah, we'll talk to Marley. But so we'll take it this way. We'll say that don't assume that your personal items are going to be of no value to your family. I think that we've achieved our purpose in the show if we've simply communicated to you that historically personal property have often been the source, if not of actual probate litigation, for example, even there's this insidious harm that happens even in the absence of actual quote-unquote litigation, meaning that often practicalities will ultimately triumph for many people, unless it's a really bad thing going on in the family. But other than that, but it doesn't mean that there is a better mood or better feelings just because it didn't break out into formal warfare in a courtroom. It still can mean that the parties walk away, these family members, often siblings, walk away with this deeply felt resentment that never made its way into a court, may not even made its way into overt expression to the other loved ones, whether it's their siblings. Because if you think about it, that's the good and bad of family. The good of family is that they're close enough that they can share things with each other that they would not share with anybody else. That's one of the virtues, I think, of family. But the downside is also true that sometimes you won't say something that you think would appear hostile or would harm or diminish or cause any sort of bad feelings in the mind of that relative because of that relationship. When I say that that's often not good, it's because it's not that you don't feel it, it's that you don't say it. And you would say it to a stranger because you don't have an investment in that relationship. So you're angry at the person who takes your parking spot, or somebody that you have a dispute with in the workplace. Though often you can express that in appropriate ways, but you can definitely express your anger. Whereas with a loved one, a sibling, a child, a parent, I mean, these are not always on the same generational tier, these disputes that we're talking about here. It's often that in that relationship, it's not expressed. So what happens? Again, it wasn't that there wasn't the ire or the resentment. Instead, it's that it wasn't expressed. So there was no valve by which that gained expression. Meanwhile, again, I mentioned to you, sometimes spouses feed this process, not necessarily in a diabolical, intentional way, but often spouses don't help. Sometimes they help, but often they don't. So you can see how there's a set of conditions here that invite what would be a deterioration in relationships of the family. So what happens in that case where, there is no litigation, maybe there's not, again, any overt argument. So the brother takes this shotgun, for example, that had been in the family for a couple of generations. The other one really wanted it, but wasn't going to express that, but still walked away with a grievance, unspoken. Now, what is the impact on the relationship over time? So I think a lot of that happens. You can imagine your own many scenarios. Maybe you can think of scenarios in your family where it's happened, where there's still this simmering resentment that exists regarding something that was not expressed and probably should have been expressed and talked out. Instead, it wasn't. And so rather than making things better in the family, it makes things worse. So I think that your goal when you do your estate planning, among your very highest goals should be that it's like doctors. What is the Hippocratic Oath? That whatever I do, I'll do no harm. I would argue that in taking care of your children in your estate, whatever you do, do no harm to those relationships. So it means that maybe you can't help out your children a lot in their lives, but whatever you do, you don't do harm to their relationships. There's something sacred about a family, and a family, by definition, is plural. Its contents are plural, and that means that you have to elevate what will be the impact on the relationships of what I'm deciding to do. And I would even go so far as to say that if you can't distribute your estate to your children or your loved ones, we'll say, in such a way that you cannot do it without doing harm to their relationships, I would argue that you should consider perhaps giving it to someone else, giving it to a charity, giving it to your church, your synagogue, whatever. There are many, many good causes for your estate. And if there's no way you can pass it to your loved ones without diminishing the quality of their relationship with one another, then this is my set of values, and you may disagree, but I think many of you will agree with me. So I'm suggesting that you think about it this way. And remember, there is an option. You can give all your stuff to somebody else. And many families, we all know, would have been better off if they had done that. I'm sure you can think of those examples. So I think in most cases, of course, that's not necessary. But it is necessary to think about, how do I distribute these in such a way to where I don't cause harm to their relationship? So that really is what this show's been about. And we focused on one aspect of your estate that is notorious for causing disproportionate problems. So hopefully these ideas have been helpful to you. This has been another episode of Life's Third Act. Till next time, take care.
You've been listening to Life's Third Act, a podcast for thriving in retirement, sponsored by TuckerAllen, your estate and elder law advisors. Each week, we discuss topics and answer questions to help you better plan for your future. For more information, visit TuckerAllen.com. Subscribe and listen again next week for another edition of Life's Third Act. The choice of a lawyer is an important decision and should not be based solely on advertisements.